The meeting of the Planning Commission and Airport Zoning Commission for November the 6th, 2019 are called to order concurrently at 6:05. Pledge of Allegiance will be led by Christopher.
Please stand, face the flag, and repeat with me. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you.
Thank you, Mr. Palmer. Could we have roll call, please?
Vice Chairman?
Present.
I can't say your name right now. I don't have my glasses on. There we go.
Okay.
Ashen LeBlanc, thank you. Commissioner Ortiz, not here. Commissioner Caraveo, not here. Commissioner Richard, present. And Chairperson Smith.
Chair present.
Thank you.
Oral communications. Please note the rules for meeting decorum on the screen. In the interest of time, these will not be read, but will be advised that the Planning Commission will adhere to these standards. This is the time for the public to address the Planning Commission and the Airport Zoning Commission for items not on the agenda. Please note that if an item is scheduled as a public hearing, you will have an additional opportunity to speak when the public hearing is opened or continued. Comments made now regarding items scheduled for a public hearing will not be included in the official record of public testimony for that item. If anyone would like to address the commission on the items that are not on the agenda, please come up to the podium. Please address your comments to the commission as a body and not to individual commissioners directly. Only very brief responses may be given to questions asked on topics not on the agenda. Please keep remarks to 3 minutes.
Good evening. My name is Farouk Mir. I'm a board member at the Islamic Center of Hawthorne. I had a few prepared comments that I'd like to be able to state on the record to the commission. There's a proposed development on Hawthorne Way with Kaiser Urgent Care, and there are some issues with the project that have a significant impact on the congregation. We're coming to you today because it's expected that once Kaiser submits an application to the planning department, it'll be reviewed and forwarded on to the planning commission for approval for a conditional use permit. A conditional use permit is necessary because Kaiser intends on building a 5-story parking structure adjacent to the mosque. And if the planning commission approves this, Kaiser will have approval to begin construction unless city council objects or appeals the decision. That's our understanding based on conversations we've had with the city council. And I'd like to just briefly go over some of the concerns we have regarding the proposed development. One of the concerns we have is why a CEQA environmental impact report was not written for the proposed project, which we believe will have a very significant impact on the surrounding community and environment. Based on a March 2016 report we've seen, there is no mention of any project on Hawthorne Way. It covers 4 distinct projects in other parts of the city, but not Hawthorne Way. In addition, we were informed recently by the city council that there's a state law that if the subject property that's going to be developed is less than 5 acres, a CEQA environmental impact report is not required. But based on our limited review of CEQA, we found no such exception. And honestly, the biggest issue for our congregation is the serious impact that the development is going to have on traffic. I'm sure you guys are all aware Hawthorne Way is about a 40-foot wide street, and it's barely enough room for a car to go one direction. If you drive down there and there's 2 cars coming in both opposite directions, one car's got to pull over. That's how narrow we're talking about in terms of the street. You know, and you know, our congregation has 5 regular prayers, sunrise to sunset, 7 days a week, and we have 100 congregants there that attend regularly and that have been there for decades. And so when you're talking about a 5-story parking structure directly adjacent, we're talking like 5 feet from the mosque, and then across from that, I believe it's like a 2 or 3-story urgent care. I mean, you can imagine the impact it's going to have on traffic. We were informed recently that Kaiser is performing a traffic and pedestrian study. And it's going to be submitting that to the city as part of its application. You know, and respectfully, the Islamic Center of Hawthorne would like to see a copy of that, because again, we do have serious concerns on the effect that this type of development is going to have on a very narrow street, and its effect on the congregants. Another concern that we've raised that we'd also like to see on the record is the effect that ambulances may have. So we're talking about urgent care, right? You know, there is a concern that ambulances may need to be transporting Kaiser patients that visit urgent care that may be necessary for emergency services and not urgent care services. And so if you have ambulances coming there regularly, that is going to have an impact directly on Kaiser's neighbors, which would be the Islamic Center of Hawthorne. In addition to traffic, parking is also going to be an issue. You know, available parking on Hawthorne Way, as you all know, it's a very packed street. It's nearly completely covered with street, you know, cars parked on the street 24 hours a day, 7 days a week. And so when you add a big company like Kaiser to that small street, it's gonna make a already congested situation even worse. And we were informed that, you know, there's going to be a 5-story parking structure, and that may address issues with parking. But that's not exactly accurate. We were informed by the representatives of Kaiser that this is not a free parking structure. This is a paid parking structure. And, you know, the reality of the situation is the residents of Hawthorne are lower income, and people are not going to resort to a paid parking lot when there's free street parking outside, right? So you're going to have a very minimal amount of residents that are going to be using the paid parking structure as opposed to still resorting to parking on the street for free. And so I don't think, respectfully, that a paid parking structure is going to address the issues that it'll have. Another very, very serious concern is safety and security for our congregants. I mean, I think it's indisputable that, you know, Islamophobic attacks are on the rise, and crimes are on the rise in our country. You know, as a Muslim congregation, you know, we are prime targets for these hate crimes. So building a 5-story parking structure less than 5 feet from a mosque, which based on what we understand it to be, it's going to give an ideal vantage for anyone that wants to commit a crime. And it's not, frankly, it's not a very good idea. We also have a school next door adjacent to the mosque, which makes this an even more sensitive issue for us.
Okay, you're going over your time limit of 3 minutes.
Okay.
What I would highly suggest you do is that when it does come before the Planning Commission, that you attend the Planning Commission and speak at it on those items at that, because I don't know if any of our other commissioners knew anything about this. I don't, so I have no idea what you're talking about. I understand some of your concerns,
Sure.
but I think it'd be better at the next, whenever it comes before the Planning Commission.
Sure. If I might just make one more comment,
quick,
very
okay.
brief. We had an approval to expand the mosque to a 2nd story, and now with this Kaiser development, that's going to seriously affect that. I mean, 5 stories right next to us, it completely creates a hurdle for our expansion. And last, I just want to say thank you for giving me the time. I understand that there is going to be a formal hearing for this. We just wanted to take every opportunity that we have as a congregation to let the city and the Planning Commission know that these are very serious concerns. We need to make sure that these concerns are taken seriously and are accounted for in terms of the approval process for Kaiser. You know, we're happy to welcome Kaiser to the city. We just want to make sure it's done in a rational, logical way that doesn't affect you know, neighbors like the Islamic Center of Hawthorne. Thank you.
Okay, thank you.
One question? Can you just repeat your name for the record one
Yes,
more time?
Farouk Mir, Farooq, last name Mir, Mir. Thank you.
Thank you.
Okay, we'll move along. Planning Commission, Airport Zoning Commission consent calendar. There are no items. Recess Airport, oh, I'm sorry, I needed to close the oral communications first.
Okay.
And then there are no items on the Planning Commission or Airport Zoning Commission consent calendar. So we'll recess the Airport Zoning Commission and we'll move to the Planning Commission consent calendar. There are no items there. We have no public hearings this evening, no items, no new public hearings. So we'll recess the Planning Commission and call back to order the Airport Zoning Commission. The Airport Zoning Commission consent calendar, there are no items. And the Airport Zoning Commission new or continued public hearings, there are no items. So we'll call back to order the Planning Commission concurrently with the Airport Zoning Commission. And we move to administrative items. First one will be the overview of code enforcement approaches.
Thank you, Mr. Chair. We're pleased this evening to bring a workshop for the Planning Commission. At one of your most recent meetings, you expressed an interest in understanding a little bit more about code enforcement and how we provide for the services within the community. So this evening, we have a duo, our team, to make a presentation. So Melissa Crosswaith, who is our Assistant City Attorney, and also Alex Martinez, who's one of our code enforcement officers. So I will turn it over to them.
Thanks.
Thank you.
First, I'd like to thank the Planning Commission for this opportunity to provide clarity and realign some of the perceptions about code enforcement here in the city of Hawthorne. And just in a way of groundwork, our primary purpose today is to provide an overview of the code enforcement department here in Hawthorne and to take a brief look into the management and operation of the department as provided. So now we'll refer to the slides.
Oh, good.
What is the role of code enforcement? The role of code enforcement is to ensure a healthy and safe environment, and it is also a time to respond to concerns from the public. Most of the times people have the question about what is code enforcement. And referring to the slide, it is a prevention, detection, investigation, and enforcement of violations of statutes and ordinances regulating public health, safety and welfare, public works, business activities, consumer protection, building standards, land use, and/or other municipal affairs. The California Constitution provides the authority for code enforcement to initiate police powers for making and enforcing laws within the city. And the department's enforcement is complaint-based and also proactive. Going into the code enforcement structure, a little bit about the code enforcement department itself. Our department sits in the Planning and Community Development Department. The department consists of 4 officers, which range from 14 to 25 years of enforcement experience. All of our officers possess some form of certification, which range from being fully certified through KCO, which is an acronym for California Code Enforcement Officers Association, and by also possessing a penal code, which is a PCA 32 certification, which is powers to arrest, which is obtained typically through a police academy. 2 of our officers are bilingual, which assists in providing service to a diverse community. Our department investigates and abates complex cases. The main goal for our department is to gain compliance. However, the necessary enforcement will be utilized in cases where the responsible party hesitates to comply. If you see to the map there, the city is divided into 4 quadrants, and this is for your view. If you refer to with 4 officers, we have 4 different colors. And that's how we're divided. But in the case of emergencies that arise, then all the officers will go in any direction that we need to go. Excellent. The code enforcement process chart. Typically, a complaint or a concern is received. Then the complaint is assigned to an officer of that assigned area from the map that we just viewed. An officer will go out to the site and conduct an inspection. At that point, it'll be determined whether or not there's a violation. If there's no violation determined, then the case will be closed. If there's a violation that is observed, then it goes into a transitory and non-transitory violation state, which during this state, we could either gain abatement and then the case be closed, or it can begin the administrative process, which would consist of verbal warnings, notice of violations, compliance orders, administrative citations. And at that point, if compliance isn't gained, from that point, then we refer all cases to the city attorney. The responsibilities of code enforcement. Any violation of the Hawthorne Municipal Code is the responsibility of code enforcement. These are some of our most common areas. Title 8, which is the Health and Safety Code. Health and Safety Code deals primarily with property maintenance, weed abatement, graffiti, stormwater pollution prevention, and so on and so forth. It also breaks down into Title 17, which is zoning, responsibilities of unpermitted use, auto repair in residential zones, and illegal marijuana uses. It goes into Title 5, operating without a business license, and unlicensed food vendors. And also Title 9, where it talks about public peace, morals, and welfare, where permits would be required for community events. Some of the problems and challenges that the code enforcement department faces typically are neighbor disputes. Examples of those would be the neighbors calling on each other on violations that they may have. We may sometimes get businesses that are operating without a business license. So we step in and we issue citations, and we can't really stop them unless there's an injunction filed with the court. Then we get into constitutional standards. We do have to allow due process, which will give the responsible party a reasonable amount of time to correct the violation. In addition to that, we have to be very careful to not violate anyone's rights under the Fourth Amendment, and also give them the liberty of their freedom of speech. We deal a lot with parking congestion in the city. We deal a lot with homeless activity. We deal a lot with non-permitted garage conversions and additions, which also lead to parking congestions. And it also leads to unsafe conditions which pose health and safety concerns in the city with building perspectives. As of the first part of the year, accessory dwelling units will be allowed as long as the legal and zoning requirements are met. And this is the first of 2020. If the requirements are not met, then plans, which would be architectural or structural, will be required to be submitted to the building department, and when and if approved, then the necessary permits can be obtained. Then the process begins until the project is signed off by the building department or the building official. We sometimes deal with illicit discharges and discharges into the storm drains. In a short period, we'll view some photos so that you can see what exactly that means. And then also we deal with non-licensed vendors, and we're talking about the street vendors, food vendors that sell corn and all that kind of stuff. Effective the first of this year, street vending is permitted within our city so long as the licensing requirements are met. Most of the time, when we do come in confrontation with the street vendor, most commonly they don't have a license, so we have to either, number one, cite them, or we have to direct them out of the city. Now we're going to go into some photographs where we show examples of property maintenance issues and other code violations. These photos here, these are an example of accumulation of excess storage on the property which create safety concerns and is also a nuisance to the community. The next slide illustrates auto repair on the right-of-way and also inoperable vehicles. And this is case by case. An example of a vehicle being briefly checked for fluids on the street is something that's probably not going to be a violation, or even changing a flat tire. But doing an oil change on the street is absolutely not permitted. So those are just some examples. And the second photo, you'll view two inoperable vehicles, and I think to some people in this room, those photos may look very familiar. Going on to the next slide, we're illustrating more violations, which are vehicles parked on the lawn, and the arrows are highlighted to the vehicles in those certain areas. The next slide illustrates non-permitted building activity. And in this, it includes all trades meaning building work, electrical work, mechanical work, and plumbing work, all in one. So this project requires plans to be submitted and for permits to also be obtained. So the next slides will show the continued non-permitted building work at that project. And then we move to the next slide, which illustrates illegal dumping at parks. This, of course, is unauthorized use of city-owned trash receptacles, and this is not permitted. This person was actually issued an administrative citation on the spot while they were doing the illegal dumping. Another issue that we deal with is bulky items on the parkway. The property owners or residents must call to schedule the bulky item pickups. And items in the public right-of-way must not block access or create any type of safety concern. And as illustrated in these photos here, there's a lot of safety concern. Going into the next slide, these types of cases create safety issues by blocking the sidewalk and street, and pedestrians can also be injured. The bulky items can be placed on the curbside after 6 p.m. the day before scheduled pickup and must not block access or create any type of safety concern. The next slide illustrates a flyer, and I'll hand it to you, and you can pass them down that way. That pretty much illustrates and talks about illegal dumping and trash and bulky items in the city of Hawthorne. And it pretty much just gives, the interpretation of the code and what can possibly happen administratively if you violate the code, and the number to also call to schedule special pickups. And all the residents have to do is call and schedule a pickup. The contract was recently changed from 2 pickups a year to 20 pickups a year, and this is per parcel. The next slide illustrates illicit discharge and water quality in the water quality storm drains. These are examples of sewer overflow, and in these cases, immediate response is required to prevent the flow into the storm drains and or other waterways. And of course, you can see here that you have a bunch of sewage there under the tire. It was coming out of a drain, and it led on into the street, which the next slide will show an immediate response by our Public Works Department. And in all cases, the responsible party is pretty much invoiced for all of the costs that may incur in a situation such as this. And this is a photo again of our staff responding to the cleanup. The next slide, another illustration of a discharge from a construction site. In this case, there was intermediate intervention to protect the storm drain. The next slide illustrates homeless activity and encampments in our city. One of our challenges, the homeless population, of course. Homeless issues are primarily addressed through a special task force which we call the Community Improvement Task Force, the CITIF group. And here the photos illustrate, you know, the homeless activity. We collaborate with other departments such as Caltrans and other service providers to alleviate the problem. If the issues arise on public property, it is handled accordingly by the city or by the necessary departments that need to come in and take care of it. If the homeless issues are taking place on private property, then our department coordinates the completion and the signing of a PPA form, which is an acronym for a private person's arrest form, and this form is signed through our police department. The signing of this form assists the property owners with arresting trespassers on their properties once this form is signed and completed. The next slide talks about, again, homeless activity, illustrates it, and they can occur both on public and private properties, and it happens all over the city. Next slide illustrates unpermitted structures and additions. And again, they must meet zoning requirements and obtain the necessary building permits. So these are just examples of unpermitted structures and additions to the structures. Next slide illustrates unpermitted garage conversions and additions to the garage conversions and or any kind of accessory dwelling additions to the yard or to the property itself. This is an illustration of what was inside of that garage. And again, it has to meet zoning requirements. Another issue that we face is with street vendors. All vendors must have, of course, a valid business license. Street vending raises health and safety concerns. And also with the food handling, the LA County Health Department is required to issue permits for food handling. And those are some of the issues that we face. The next slides illustrate some of the street vending activity and what they have on their carts. They're commonly equipped with non-refrigerated mayonnaise and other non-protected perishable items. And the vendors normally wear no protection. Examples, gloves and or hair nets and etc. These are other illustrations of continued street vending, selling from their trunks of their vehicles in the supermarkets and or in shopping complexes. Going into the next slide, you have set up there of churros being sold, and then the phones, free phones in front of the stores. Those also require types of permits. And so the question comes about how does code enforcement address these violations of the municipal code? Traditionally, we have three approaches. They range from administrative, civil, and or criminal. Other approaches that we practice are informal meetings and conferences. But typically, the administrative process itself begins with, and again, it could be case by case, begins with either warnings, a notice of violation. Sometimes we can go into a second notice of violation or even a final notice of violation, which ultimately leads up to a compliance order. And then from there, it leads to an administrative citation. If we don't obtain compliance by that point, then we refer all cases to the city attorney's office for further. And so the next slides, and I have some more paperwork here to hand your way, are examples of what we issue on the field. The first sample that you're going to view there is a sample of an inspection and correction notice. These notices are typically utilized in the field to provide an immediate written notice. In this notice itself, we provide the description of what the violations are. This notice may also include what we call a stop work order for unpermitted construction and or activities. So this is what we hand on the field. The next, if we don't approach it from a field level, and we go through formal notification from our office, then now it moves to a notice of violation. And the notice of violation is more formal, of course, and it addresses, pretty much in the first column, it addresses the municipal code violation. In the second column, it describes the actual code, it's descriptive. And in the third column, it gives you the corrective action. So again, these are just samples of some of the things that, some of the violations that we address out in the field, and some of the corrective actions that we instruct with, of course, a reasonable amount of time. At the very bottom of the notice itself, it gives you a reinspection date. And again, failure to comply can lead to further enforcement action, which can, again, go to an administrative citation or be referred to the city attorney's office. In cases where we have situations that are more long-term and more stationary, for instance, like a garage conversion, then we issue compliance orders. And the compliance orders is pretty much the same general layout, identifying the code, giving you the description, and again, the corrective action. And if you go to the bottom of the columns, it gives you a little bit of verbiage of what it entails in reference to the compliance order. These violations must be fully corrected within 30 days on the date, from the date of this letter. If not, an administrative hearing will be held to impose a $1,000 fine for every day that the violation continues, and so on and so forth. And of course, the authority that allows us to initiate this are those code sections that you see there listed on the notice itself, on the order. And on the back of it, it gives you the procedures for administrative hearings and also the procedures to appeal the administrative order itself. And then the city attorney will speak to you more in reference with that in a bit. If, from that point, if we don't gain compliance through any of those notices, then we initiate an administrative citation. And again, these are samples just for your view. Pretty generic: name, date, time, who, what, when, where, why, and how is basically what we put on these forms. We indicate the description of the violation, we sign it, and then we include the fine that's associated with the code. And on the back of it, which I did, kind of a side-by-side illustration of it, but the back of it gives you a description of if you would like to appeal the citation. It gives you the time frame of when and how to do that, and all the other scenarios that it has there. And again, these are, for view. So again, with the administrative citations, the description is pretty clear, and it tells you what it is that it entails. The fines are set out by the administrative citation schedule, which we call the bail schedule, and that's approved and adopted by the city council. Every day that the violation occurs, it either could be a new and a separate offense, and the administrative citation may include multiple offenses. It doesn't have to just include one. So if you have five to 10 violations at a property, and they have not complied, then we'll address all those issues in reference to fines on the citation itself. And so that pretty much concludes the overview of the Code Enforcement Department, and then now Melissa will speak about the legalities.
Thank you, Alex. Thank you, Commissioners. So I will speak a little bit about the enforcement aspect, the tools that we have in our code or just in law that assist us, because obviously the City Council places all of these requirements upon the public. It's all contained in the municipal code, and then we have code enforcement tasked with enforcing it, but how do you actually get compliance? We talked a little bit here about the informal processes, so I'll talk a little bit about the other tools. There's administrative, there's criminal, and then there's civil. And within civil, there's kind of a lot of different areas. So first with the administrative process. So already one of them we've talked about, Alex already talked about them, administrative citations. These are a really effective tool in the city that we've utilized. We have two provisions in our code. 1.23a talks about continuing violations, and those are the ones that are more long-term, right? The things, perhaps it's a structural issue, perhaps it's a zoning issue, for example, unpermitted use. You would be citing under 1.23a. If they do not comply, there's a hearing that's involved, and there are obviously fines. A note about citations. So with fines, Alex mentioned the bail schedule that we have. So the bail schedule is approved by the City Council. It basically is a list of the fines for each and every violation of our code. So for example, anything having to do with property maintenance, 8.20.030. A very typical fine schedule would look like this. The first violation would be $250. The second would be $500, and the third would be $750. I think at minimum it's $100, $200, $500. But most of ours all the sections of violations would be $250, $500, $750. In some cases, our fines are actually $1,000. I think for fireworks, for example, $1,000 fine, something that is appropriate to the level, like the safety issue that it involves, right? We also have 1.23b, which is for any violation, and that's typically for anything that can be corrected almost immediately. For example, maybe debris. You have debris or trash that can just be picked up and thrown out. In both cases, either with the 1.23a, where you have a compliance order, or 1.23b, where you have just a citation, I would call it. Obviously, we have to provide certain information, and we obviously have to provide appeal rights for an individual. So that's always included. These can be appealed to Superior Court. So any person that's aggrieved by administrative citations also has that recourse. And I talked a little bit about when we use each one. So this is a very effective tool, and it's all spelled out in our code. And as you heard, code enforcement utilizes this quite regularly, because we've learned that over the years, this does really help people to comply. Another tool that we have is revocation. In many cases, when there are egregious violations and someone is maybe holding a conditional use permit, that's a very typical example, or they have a certificate of occupancy, we can go through a process and revoke it. These are considered entitlements, so obviously there's due process. It would require notice. We've talked about due process a lot. Notice. There has to be a disinterested body making a decision. There has to be an opportunity to hear evidence, an opportunity to rebut, just kind of the typical due process requirements. So for example, a CUP, if we ever had to revoke or modify a CUP, you would be the hearing body that would hear that. And code enforcement would actually be the ones providing all the evidence. They would have to show pictures and show all the instances, the dates, the chronology of all the times that this particular property owner violated the code. We can also revoke business licenses. This is more, it doesn't have the due process attached because it's not considered an entitlement. A business license is actually just a tax that you pay, the certificate that you receive. We've done this actually in the city a number of times. It's a less formal process. Usually it's a hearing before the city manager or their designee, and if we determine that they were in violation of their business license, perhaps they did not provide correct information on their business license application, we've revoked their business license. And I do want to note, and I think you kind of alluded to that, even though we may revoke a business license, that doesn't mean that the business actually stops operating in some cases. This just takes away their certificate, which exposes them to additional enforcement, which means they could be cited for not having a business license every day until they either cease operating or they do whatever correction they need to do in order to continue to function as a business. Another tool that we have in our code is what's called administrative or a summary abatement. It's two different types. Obviously, in our code, we talk about what's a public nuisance. Example, Chapter 8.2, property maintenance. Those are typically the ones that we talk about the most. So if we determine that we need to abate this public nuisance by our own crew with our own people, we have a process detailed in the code. We have to provide a notice. The first step is providing a notice of nuisance and intention to abate. We have to provide rights of appeal. We have to serve the person. We have to go through all these processes that are laid out in the code. If it is creating an imminent hazard, we can do summary abatement, which basically means we provide some notice, but we immediately go ahead and take care of the issue. For example, if it's some sort of a discharge issue, we can summarily abate. And we typically do the accounting. That obviously has a cost. We're doing it ourselves. So there's a cost attached. We'll do an accounting, and that has to be reimbursed by the property owner, whoever is a responsible party. Important to note is that we still have to have consent. We either have to have consent or we have to go to court and get an inspection or an abatement warrant to actually go onto the property and abate the nuisance. But it's still an effective tool because in some instances, just having a property owner seeing that you're going through this detailed process and having a hearing in many cases is enough for them to understand the seriousness of what's going on, and they may, in some cases, abate.
Melissa, a question
Yes.
or clarification,
Go
because
ahead.
there's also situations where there's an emergency, for example,
Yes.
a building that may be
Yes.
either damaged by fire or it's open and accessible. So I think you can also utilize your police department to make that finding so that you can get immediate cause to go onto the property.
Right, that would be it. That would be summary abatement. If we needed to do it, then we go ahead and do it. There's still always a risk, right? But if we have police and we have code enforcement and we have other building officials that can say that this was an imminent threat to health and safety, then we have a better legal basis. But again, it's a tool. It's available to us if we need it. So just in general, right, there's advantages and disadvantages to every approach. When we're talking about administrative processes, things that are done internally, they're a good first enforcement tool because it can be very effective. A lot of these are fines. A lot of administrative citations involve fines. And as I kind of alluded to, $250, $500, first offense, second offense, $750, and that's for each offense. And I know Alex mentioned every day can be a separate offense, so every single day you can be cited. If you have 5 or 6 violations on your property and we're going out there every day for 5 days, that can get very expensive. And so that's our means of ensuring that you comply. Nobody wants to have to pay these fines. It's most of the time it's informal procedures. Even the hearings that I talk about, those hearings are going to be before a planning commission, or they're before a city manager or a designee. So in many cases, it's in-house folks that are doing it. And it's efficient, it's quick, and it's cost effective. The disadvantage I've also already alluded to is that it doesn't have the same weight as a court order, for example. We still have to have consent, or we have to have a warrant, something to be able to go on the property, or again, an administrative citation is just a citation, right? You have to pay it. If you don't pay it, the fines will accumulate and you may eventually be sent to collections, but it's not the same as a contempt process that you would have available to you if it's a civil process that you're utilizing. So the next type of tool that we have is criminal enforcement. So any violation of the code can be considered a misdemeanor unless it's designated as an infraction. But in many cases, the city attorney has the authority to determine if something will be an infraction or a misdemeanor. Obviously, a misdemeanor carries higher penalties than an infraction. So it's good to have that discretion, so that in some cases we say, this may be an infraction, but we're going to charge this as a misdemeanor. If it's an infraction, the maximum fine is $250. If it's a misdemeanor, it can be up to $1,000 or 6 months in jail, and that's per charge. So if there are multiple violations on a property, it can be several charges. In the past, a very typical result that we would get is the person would be on probation. So if they violate the code again and they're on probation, then they're in contempt, and there are some additional penalties that can be garnered. And again, each day is a new and separate offense. So that makes a big difference for a lot of people, because the charges will start to add up and the penalties will start to add up. And the more charges you have, the more likely you are potentially to look at a more serious penalty, like jail time. And we have had that in the past where someone had been ordered to go to jail. So civil enforcement, that's the other process. So we're out of admin, we are out of the criminal court, we are in a lawsuit situation where it's a lawsuit. You can initiate a lawsuit for abatement and an injunction. There are also a number of specialized laws that have to do with abatement and injunctions. There's gang injunctions. Anyone heard of gang injunctions? Drug house abatement. These are essentially bodies of law that are statutory, that have some additional requirements and some additional cost recovery. But we could file a lawsuit on anything that we consider to be a public nuisance. And essentially, it's a two-part test when you go to get a preliminary injunction. A preliminary injunction basically means that they have to cease the activity immediately. It's a court order that tells them they have to cease it. So if we show that there is a nuisance, then the harm is presumed. So it can be very effective because you can get immediate compliance. This is often used for substandard buildings under state housing law. That's one area for residential. It's a lower burden of proof. It's preponderance of the evidence, not beyond a reasonable doubt. There are civil penalties available. Civil penalties can be up to $1,000, and case law says as long as it's not excessive, then they're lawful and reasonable. And we have seen cases where civil penalties will be many, many thousands of dollars, over $25,000, $50,000, $100,000, and they've been upheld. Because again, just like misdemeanors, just like an administrative citation process, every day and every charge is another $250, $500, $750, $1,000. It can get up there. This is it's a tool that we have. It's also not used as often because we do get such good success with administrative citations. That tends to get people to comply. We don't have to have this additional step of going to court. It's also very, very time consuming. It's a lawsuit. It's a full-blown lawsuit, and it's very expensive. But it is something available to us when we have very, very serious offending properties. And I mentioned a little bit about how there are kind of specialized areas of bodies of law out there that talk about nuisance and are ways for cities to have cost recovery. One of them, and I thought I would highlight this one because we've done this many times in the city now, is receiverships. A receivership is a lawsuit. It's still the same process. We're asking for abatement, injunction, and the appointment of a receiver. And what happens is what we ask the court to find someone to take over the property and fix the problems, because we've determined that they are unwilling or unable to comply with all the orders. I mentioned earlier that there have been people that have gone to jail. Well, that's why sometimes criminal isn't effective, because if people can't comply, they don't have the money to go through the permit process, for example, then the facing of jail time isn't a huge deal for them. It's not going to be effective. They'll go to jail. They don't have the money to fix it or the abilities. So this is another option. We ask the court to appoint someone. That person takes over the property and gets compliance. Compliance is guaranteed. It's taken care of through the court. We are reimbursed our costs. It comes out of the property. This particular body of law does allow it for single family, multifamily, any commercial properties that meet the requirements. They have to it has to be a substandard property, basically, where there's a threat to health and safety, something very egregious, right? We are taking away the person's property, so it has to be something pretty serious. And we have done this several times. We are on our 4th receivership in the city. It's become a very effective tool for us because we have found that we have a subset of people that are just really unwilling and unable to comply, and this helps them to get compliance. So here are actually a couple of examples. We just gave 2 of them so you could see what they look like. This is the first one that we did on Broadway. This property was on Broadway. You probably remember it, right? The pigeons, lots of pigeons.
I used to call it Monster House.
Monster House, yeah, or Pigeon House. So that was one of the first ones that we did, and it did take some time. I think it was about 1.5 years until we were able to get it done from the point of filing the lawsuit to actually having it move in, or in this case, sale ready. It was about 1.5 years. Obviously, with a receivership, it's a lawsuit, so again, it's time-consuming, it's expensive, there's a lot of notice that's involved, so there's a lot of different steps that we have to take. We give a property owner many opportunities to comply, but if they don't, then the court will appoint a receiver. And here is another example. This one is on, I want to say 134th. This is 134th? 134th. Okay. So, that's another good example where we were able to achieve compliance utilizing a tool that was provided to us by state law. Does anyone have any questions? I went very quickly on my part, but that's essentially our presentation. Here we have obviously we've noted for you the contacts. We have Oscar, Alex, Chris, and Steve, our code enforcement officers. And we have a very, I have to get to this slide, a very cool slide. So anyhow, are there any questions? Can I answer any questions for you? Either of us, one of us.
Okay, I actually have a question. So is there anything in the Hawthorne Municipal Code that dictates how long a large building can remain vacant before you can intervene?
Well, typically what you look at for a property is not so much vacant, it's the condition of the property.
Blight.
It's blighted, okay. Right? So there are several sections of our property maintenance section. It's chapter 8.20 that address that. And I believe the city council is voting on something that would be specific to vacant properties. I think it's on second reading for next week. And that addresses a time frame for how long something can sit vacant and be blighted. So there will be something.
And actually to clarify, because the ordinance really just specifies that if you have all these other problems, so if you have property maintenance, unpermitted structures, whatever it might be, and it's vacant, being vacant is another item that we can use for citation purposes and for enforcement. So it just adds one additional layer of review and opportunity in terms of trying to gain compliance. Frankly, sometimes when you're dealing with property owners who just have vacant buildings, if they're otherwise maintained, they're not necessarily illegal, right? What we're really looking for is whether there's a public health and safety threat. I've seen in cases where someone has started construction, then they have stopped because of financial reasons, and you have this derelict building that's 80% complete, and it just sits there and sits there. That's an example of where you can have multiple violations because the permits expire. You then have unsafe conditions on the property, and it's vacant, right? And then you can go through an enforcement mechanism, whether it's administrative or ultimately through a civil or a criminal, and then try to gain compliance.
So if there's illegal activities that are happening inside the building that's vacant, that would also be considered health and safety, or if it's being occupied by homeless, that would also, okay.
Right,
so,
it could be. Those can be violations, and so we would have one of many tools to
And does someone
utilize.
have to complain regarding the building, or can code enforcement just decide that, this is very unsightly and we're going to cite it, or does someone necessarily have to complain against the building?
Well, we use both, right? And that's Alex talked about that. We're complaint based, so someone
Yes.
can complain, and then they'll go out and investigate. But they also each have quadrants, right? So they're watching the properties within their quadrant, and if they notice that there are some consistent violations or some properties that do need to be addressed, they will go ahead and do that on their own. They'll initiate it on their own. Correct me if I'm wrong, Alex.
That is correct.
That's right.
Right.
Okay.
Okay. Thank you.
It's always healthy to have a combination of both being proactive as well as reactive to community concerns. Sometimes in communities, neighbors are less likely to turn in another neighbor. So you do want your code enforcement officers to actually be eyes and ears within the community. And so I think here in Hawthorne, you actually do have a good balance between the two. I've actually been very pleased working with the 4 officers. They exhibit a lot of good communication with the community. They don't start off immediately issuing notice of violations or citations. They really want to talk to individuals and make sure that there's education, that there's good communication, and that there's an understanding of what needs to happen. When individuals are not being responsive or they just flat out don't want to do it, then we have to escalate and use the more, I guess, the stronger tools that become available. And, not all cities will use administrative citations. Sometimes elected officials get hesitant because, people complain, oh my gosh, you just cost me $5,000. But in reality, that gets people's attention. And in the Hawthorne community, you have a combination of owner-occupied units, a lot of renters. You're about 75% renters. You have a very diverse business community. Some which you can tell have very good attention to detail. They're very proud of their businesses. Others, not so much. So there are different tools that work differently with individuals. Some respond very well just to have communication. Others need to have the incentive of the citations. It is rare to have to go to civil and or criminal proceedings, mainly because it's usually not necessary because you can usually get people's attention through the citations, right? But if necessary, the city does have a lot of tools available within the municipal code, and they can be very effective.
Any other
Questions?
Yes, and thank you. Not for me. Thank you.
I have a question, a couple questions. Going back to code enforcement for the nuisance or issues created by encampments by homeless. Does the city or the special task force, do you always have an option to offer the homeless people in terms of shelter, or is your concern mainly just to remove them from the properties?
When the task force is out there, coordinating the homeless issues, there are other resources that accompany the police department and code enforcement that address those specific issues, and they do refer them to temporary housing or shelters or whatnot, or direct them to some type of good assistance for them.
Okay.
Yeah, and I will note that we have one code enforcement officer who's more focused on the homeless issues, and this individual often starts work at 4 o'clock in the morning, because in order to intervene and or to communicate with the homeless, you need to be able to find them before they're starting to travel through the community. The city does work with a lot of different nonprofit agencies as well as governmental agencies to try to kind of connect people to resources, but housing is a big concern. There's not enough shelters available. And sometimes you have individuals who don't want to seek the shelters. So you're trying to provide at least enough service to the individual to assist them, but you're really also needing to protect the community as a whole. So making sure that there's not law enforcement issues and or property maintenance issues that are being created as well. So it's kind of a fine balance, but yes, every time they're going out, they are also trying to provide resources or at least access to resources.
My other question, I'm not sure where it falls under, but when the city provides permits for filming, do you know about the requirements that the business must meet? I mean, does it have to be a safe area for filming to take place? I mean, because people are going into that facility, right? Or maybe around the building. Is there any specific requirements for that?
Off the top of my head, we should still have an ordinance, and it has a number of different requirements. What happened a couple years ago is that the responsibility for ensuring that those were complied with moved to a third party. So there's an ordinance that tells you exactly what the property owner needs to do.
Okay.
I don't recall the requirements right now off top of my head, but I can get you a copy of the code
Yeah,
section.
there is a distinct process that needs to be followed in order to get a fill permit, and the application needs to be submitted to the city. It details what's involved with the project, how many days, the hours of operation, how many people, what are they doing. That is reviewed by a number of different departments, including the police department. And if it's deemed necessary, the film crew will be required to retain some of the police officers in order to provide traffic control and/or kind of supervision of the activity. Recently, you may have participated or been aware of the home makeover, the Extreme Makeover Home Edition. They were required to have police officers on duty at all times during the filming, and that was a fairly soft type of filming. The ones that are more active require even more of a response from the city, could include Public Works as well as the police department. So there are definitely provisions in place, and the city gets cost recovery for anything that involves staff time.
Thank you.
I had a question I wanted to ask, specifically regarding the receivership. So we mentioned about this house over here on Broadway, and when those houses or those buildings are taken over by the city, does the city retain the proceeds from the sale?
No, the city is reimbursed for any of its costs. So that means costs that are associated with code enforcement, with attorneys. That's the two big costs there.
Contractors?
So whatever we spend, we get reimbursed. And if it is sold, in some cases, the property is not sold. There's just a lien that's placed on the property. But we are reimbursed. So we don't receive the proceeds from the sale unless it's for reimbursement.
Okay.
Right, but then anything that would be remaining would go back to the
Back to the
original
property
owner.
owner, yeah.
That was the next question. So
Right.
those properties, after they are deemed no longer blighted, they are returned to the original owner?
It's temporary control only,
Well,
just to get it
Right.
taken care
In
of.
some cases, they may continue to be under the ownership of the original party, and that would be in the case where there's typically a lien that's put against the property. But in other cases, we've actually physically taken the ownership away from them, and so the property is sold to a third party. And any proceeds, just like in a normal transaction, any of the profits would go back to the original property owner as if they were selling the property. It's just that they're being forced to sell it because they were shown to not be able to maintain the property.
Okay. And the requirements to begin a receivership, how does that work?
Well, you have to have, obviously, a property with violations that are serious, and the statute lists different things that could fall under, would be considered a danger to health and safety. There's also quite a bit of noticing that's required and quite a bit of other attempts to make them to comply. We have to show that we've tried other things. We've administratively cited, criminally cited in some cases, and we've still been unable to get compliance. So there has to be quite a bit of documentation showing that we've made the best effort we could to get the property owner to comply, and that they still are unable to. So it's a long process.
Right, and then ultimately, it's the court that decides whether a receiver should be provided for.
Yeah.
We're making the request, but the court makes that decision. We currently have one property two properties, they're side by side, that have been authorized by the city council to go through the receivership process. We have not yet received a court date. So sometimes, even though we're working to get it done, it takes still months and months to get through the process.
Thank you.
Okay, thank you very much. I would say, you have one more
No,
question?
sorry.
I had
Okay.
a question.
Oh, I'm sorry.
I know we brought it up before about the Ralph's that shopping center on Hawthorne and 118 Street. Noticed that there's been a lot of trash during the day and a lot of homeless out front. Have they been cited? Do you know?
That property's, there is an active and open case on it, and we're dealing with those issues accordingly. So citations have been issued for noncompliance at that property for those issues.
Okay, thank you.
Thank you. I want to say it's a very spectacular presentation. I like the PowerPoint and all the information you've supplied us with tonight. I'm thinking we might, after all of this, be qualified code enforcement officers.
We put it on our resume.
It takes a village.
But I wish to speak with you for a moment after the meeting in private. Thank you. Okay.
Actually, Alex will probably not stay to the very end of the meeting, so perhaps what he can do is if he has a business card with him, he can leave business cards with the Planning Commission. Unless you want to stay forever.
I could call you. I'll call you.
I might hang around.
Okay, the next item would be the review of recent state legislation for accessory dwelling units. Who's up?
Thank you, Mr. Chair, members of the
Thank you,
Commission.
Madam Secretary.
So I recently prepared a memorandum that was provided to the city manager and then was shared with the city council. I wanted to make sure that the commission was afforded the same information. And if you read this memo, you were probably a little shocked and amazed, as the code enforcement officers were when I explained it to them. But in short, what is happening is that the state in approximately 2017 started initiating various laws to basically facilitate the development of accessory dwelling units and junior accessory dwelling units. You know, typically junior accessory dwelling units are very small units that are generally carved out of an existing house. The accessory dwelling units, most people call them granny flats or second units. Those are typically occurring somewhere else on the property, commonly by converting a garage. And there were a lot of standards that were established in 2017 that cities were just getting ready to kind of get their arms around and understand and be able to implement in a fair manner. In fact, the city of Hawthorne just implemented their ordinance just a couple of months ago. But what's happened now is that the state, responding to what they perceive and what really is a housing crisis, they're increasing the opportunities for creating accessory dwelling units and junior accessory dwelling units. And by doing so, they're pretty much eliminating or minimizing anything that cities can do that are considered to be a hindrance or an obstacle for the creation of these new units. I've illustrated in this memorandum 3 specific bills that were just recently passed. One is Assembly Bill 68, the other one is, my glasses on, 881, and then also Senate Bill 13. Collectively, what they do is they make sure that site development standards are brought to pretty much a fairly minimum standard. For example, on setbacks, some cities, because of their different geographical, their locational standards, they would have setbacks that might be 5 feet, 10, 15, 20 feet. The state now says that if somebody wants to do an accessory dwelling unit, you must allow them to have down to a 4-foot setback if that's what's necessary in order to facilitate the development of an 800 square foot accessory dwelling unit. Our code right now is 5 feet, so we're going to have to amend that. The code also says that you have to basically eliminate most parking requirements. It also says that if you have an accessory dwelling unit and you decide that you want to have a junior accessory dwelling unit, you can do that too. So effectively, it's allowing for triplexes in what we consider to be our single-family zones. That's a real game changer for a lot of communities. We've always looked at our single-family areas of being kind of the sacrosanct, protected areas where it's single-family homes with green yards and backyards where kids can play. But now you have more and more people looking to add units. Now that's a good thing in terms of being able to provide for the housing stock, but it's also a constraint in terms of the impacts it will have on the neighborhoods, because we'll have more issues with parking, more issues with density and population within our neighborhoods. One of the controls that cities had been relying upon based on the 2017 law was that you could at least require a homeowner to be an owner-occupied unit in order to have the ability to have an accessory dwelling unit or a JADU. The state has now put a moratorium on that and said for the next 5 years, you don't have to be owner-occupied. So we've seen just within the last couple of weeks, numerous calls, numerous people coming to the front counter asking as an investor, can I buy a property and can I add another unit or two onto each of these properties? We can't say no. The law will be effective January 1, and we have to make sure that we don't have obstacles in place. We will have to facilitate the ability for individuals to build all of these units. I expect we're going to get a lot of people in the community who are not happy about this, right? So I wanted the commission to be aware of it because it is not something that you have any direct responsibility for. It's nothing that you can intervene with, but you can certainly help to educate and communicate with the community in terms of what we may have to do, but also what we can choose to do. One of the things that I think is important within a community is to understand community culture. If property owners recognize that they have friendly relationships with their neighbors, that they have respect for the community, you know, we would hope that they wouldn't take too much advantage with this new law, and they would try to be reasonable in terms of where they locate these accessory dwelling units and JADUs, and that they don't unfairly burden our existing neighborhoods. That's an ask, but it's not a requirement. But I do think it's important for us to talk amongst our neighbors, amongst people who may be wanting to invest in Hawthorne, so that they try to be balanced in their approach with the community. We don't know what's ultimately going to happen with the state, but we recognize that, you know, the state's very concerned with population growth over the next years. Currently, we have about 40 million people within the state. By 2050, they're expecting that to increase to 50 million. That's a lot of people to try to accommodate within an area, within a state that already has a lot of built-out communities. We've talked before about, you know, the state not necessarily wanting to take up all of our agricultural land or having people living in areas that really aren't well suited for housing. So the state has an interest in making sure that people are closer to the jobs, they're closer to where the amenities and the resources are. But that means that communities are going to change. Our single-family neighborhoods, as we know, will likely just feel differently over the years. But how we work with that as individuals and as a collective community, I think will make a difference. From a planning perspective, we're going to do our best to talk with people and try to make sure we get the best standards that we can. But we ultimately will find more and more coming in. And I think as it becomes profitable, you know, you'll hear the word getting spread and even more and more will come in. But I did want to provide an update to you this evening. If you have any questions regarding this legislation, I'm happy to answer it. What we expect to happen in terms of next steps is that we'll be working with the city attorney's office and we'll be looking to see what revisions need to happen to our own zoning code in order to be consistent with state law. If we don't make the changes to our own code, we still have to be consistent with state law. So, but it's a matter of being transparent, it's a matter of being honest in the way that we're representing things to the community. So with that, any questions?
Yes, I thought I saw that one tool that the city does still have is to identify design standards for. And so we can at least make sure that what's being built is quality and has certain aesthetics that will be of a higher level, right?
Right, and that is one of the things that we'll be looking at. You know, the state has kind of given us the parameters of size, shape, and location. We know that they can be 16 feet tall, they can have 4-foot setbacks, they can be certain sizes, but there are still some design parameters that we can use. But the state says that you can't use those as an obstacle or as a reason to deny the project. Right.
Mm-hmm.
Would it require design review, or just there's just design standards that we have for?
I think it'll be more design standards. It will not be a public hearing process, so they won't be coming before the Planning Commission.
Okay. And then, so it sounds like they're limited to 16 feet in height, so they can't have one that's a 2-story, like maybe over a garage or something.
Well, we can provide for that, but that can trigger different requirements. Right, but the ones that have to be facilitated are the ones that meet the minimum standards.
Okay, so we can limit it to the 16 feet in height, and not allow for any like that are over a garage or accessory structure.
Potentially, but I think the city may want to allow for a process where you can consider that, because on certain properties, it may actually be better to put something over a garage, especially if the property owner wants to retain the garage. Because then you may be maintaining more parking, which is beneficial for the neighborhood,
Yeah.
right? So there's a little bit of a formula I think we'll have to work through.
And then will the ADUs count towards our arena numbers?
Absolutely.
Okay. Is that regardless if it's low income or?
It will still count. I don't know if they're
If it's
automatically.
built in the right time, period.
Yeah, well, they'll still count. It's just which RENA will they count towards, which housing element. There's kind of an assumption in the state law that ADUs will be affordable to a segment that's below the market. You know, so they'll be moderate, low income, very low income, somewhere within that range. But most ADUs, there's no requirement for them to actually guarantee that. That's actually been one of the discussions, is that if we're going to be giving property owners, you know, this privilege of developing all these units, which is a good thing from a housing production perspective, should they be required to make them affordable and to guarantee the affordability? Right now, the state law does not require that.
And Ed, one more. I know some cities they limit development of ADUs or junior ADUs or even conversions, like so they don't allow it on lots that are too small or like less than 6,000 square feet. Is that something that we could do?
That is something that we currently have on the books. We do have some limitations in terms of being able to provide for a new ADU. The new state law, however, removes those standards.
Okay. That's all my questions.
Yeah. Have I thoroughly depressed you?
If not, it's my turn.
Yeah, right. No, you don't.
I just have
Yours
one,
is-
one
go ahead.
question. Just what were can you list the bills again? What is it?
It's actually listed in the memo as well, but the three primary ones to look at would be Senate Bill 13, Assembly Bill 68, and Assembly Bill 881. I should also note that there are some additional bills that were passed. There was quite a bit of housing legislation that were signed by the governor. One of the things that had been discussed with past, I guess, maybe workshops or with other cities, is that homeowner associations where you had PUDs or condominium associations, there was a perception that they did not have to comply because they could have their own independent rules. That's been changed too. So there's no protection now just because you have CC&Rs. A property owner still has the ability to come in and ask for an ADU. Because I know that was a particularly interesting discussion for some of the I guess, more high-end gated communities like Rolling Hills, Hidden Hills, because they thought they could just, you know, kind of put up their little flag and say, you know, you can't come in here. But the state has now removed that.
Yeah, the unfortunate, just to comment, the unfortunate part is that it doesn't really affect those communities very much because those are primarily owner-occupied residences. So,
Right.
you know, there's not much of an financial incentive to, or there's not that much of an incentive for owner-occupied to maximize the amount of units on their property, you know, because they also want privacy and, you know.
Right.
But if in lower income communities where there's a lot of owner-unoccupied properties, there's that incentive to maximize rental income. So that's where, you know, you're going to get overcrowding and, you know, and there's not going to be a shared burden throughout the state of California, especially in the much higher income communities. So that's
Right.
unfortunate.
And I think your point's well taken because these ADU laws will impact communities differently. You know, those communities that have larger properties, adding an ADU or a JADU really won't make a difference because there will be on-site parking. It still gets absorbed within the property. But when you have more dense populations like Hawthorne and Lawndale and Gardena and Hermosa Beach, I mean, after a while, there's not a lot more space that you can carve out. It ends up being pretty much all buildings because you have so many people trying to live within very small properties.
And it could affect some of our 360 Fusion, because they have community facilities district that they pay, and so their property taxes are more than typical. So even though it's a gated community and things like that, it could potentially be income to help them pay down their taxes.
I just have one last question, if I may. Now, did they take into consideration the census? Because I know that between 2000 and 2010, Hawthorne population did not increase at all. So would that at least weigh into not needing to create that many dwellings if the city itself isn't overcrowded? I mean, shouldn't it?
Well, from the state legislature perspective, they're looking at the state as a whole, and they're recognizing that there are different types of communities. I mean, communities that you may have in the San Joaquin Valley are very different than San Francisco, Sacramento, Los Angeles. But as a whole, because there's such a gain in population and there's such a crisis in terms of housing affordability, they're finding that ADUs are a less expensive way to be able to provide units. So the issue of whether or not a community is gaining in population or not, they're not looking at artificial boundaries at your jurisdiction line. They're looking at what's happening within the subregion, the region, and the state as a whole. And it could actually be argued that if your population didn't increase, then maybe there's constraints to housing production. Right? One point I would make, though, which I included it in the memo as well, is that it's important to recognize that the laws that are coming from the state are not just coming from the governor. They're coming from the assembly members and the senators that are locally representing you and everyone else within the community. So if you look at those who have been approving these laws, the vast majority of assembly members and senators have been in favor. So if there are concerns about what's happening with state legislation, it's important that you have those links with your local representatives. Because at this point, they're hearing from a variety of different resources, and I'm not saying that these laws are bad per se, but I think they're not necessarily reflecting local concerns. And so it's important that they hear from everyone.
I don't think they're taking the full picture. I mean, I think they're being one-sided and not realizing the negative impact that if this does go into effect 5 years down the line, it's going to be worse. It's not necessarily going to be for the benefit of the city.
Right, I mean, because there's a huge amount of, Chris is going to be talking about this in just a minute when we talk about the amount of units that we're kind of being obligated to produce. I mean, do you do it by infiltrating your single-family neighborhoods, or do you try to be more thoughtful in terms of having denser housing in places where it may be more appropriate? But at this point, the state's basically indicating, we're not sure you're doing either, so we're just going to require you to do both. Okay?
Thank you.
Okay. And you on?
This would be the third workshop, so we should probably introduce it, if there's no further questions on ADUs.
Probably one more. So if it's a second story, then it's allowed like discretionary review.
And what does our current ordinance provide for?
Right now, we don't permit second-story ADUs. It conflicts with our existing municipal code. If you have a single-family home and you have an accessory structure in the rear, the accessory structure, whether it's a dwelling unit or just a structure, is limited to 12 feet. You're not permitted to have a two-story rear unit unless you have a planned unit development with each unit is for sale. So the way our code is written now, you're not permitted to have an accessory dwelling unit on top of a garage unless your garage is attached to your home. If you have a detached garage, you cannot do it.
Right, so the change with the state law will take it to 16 feet, but that still doesn't really allow for a second story. So when you're ultimately looking at your ordinance, you might want to consider whether you want to allow for a second story. There's probably a few cases where it may be appropriate, but in most cases probably not, unless it's attached to the house, where it's just looking like it's an oversized, single-family home.
Okay. Next item is update on Southern California Association of Governments, known as SCAG. Final proposed regional housing needs assessment, RHNA, allocation methodology.
Okay, thank you. This is just a workshop, not going to be real, formal. And we had a presentation for RENA a couple meetings ago, and so I'm just going to give you a brief kind of overview about what happened, how the city has responded to our last RENA cycle, was the 5th cycle, and kind of what the 6th cycle is going to look like. So hi, my name is Chris Palmer. I'm the senior planner here at the City of Hawthorne.
Hi, Chris.
Nice to see everyone. So I'm just going to start with a review of some concepts. Terms you're going to hear is extremely low income, very low income, lower income, moderate, above moderate. And so extremely low income is 0 to 30% of AMI, which is the area median income. So for Los Angeles County, the area median income for a family of 4 is $73,100. So if you had a family of 4 and you made $73,000, you qualify for median income, which will get you a certain level of affordability for your housing. So, for example, extremely low income for a family of 4 is $31,000. So, RHNA, RENA, Regional Housing Needs Assessment. In the past, let's see what the city's done. In 2014, the City of Hawthorne updated its housing element. RENA for the city was 683 total units. So extremely low, 85, very low, 85, 101 for low, moderate is 112, and above moderate, 300. And so when we talk above moderate, that's typically considered market rate housing. So this is what the city accomplished by 2018. So we were required 683 units. We produced 821 units. Although we produced over that number, we didn't do it in all the categories that we were required to do it in. So we still have a remaining need in the 5th cycle for 161 units. And those units are extremely low and very low. So what's happening today? What is the state and SCAG up to? Presently, SCAG updated its RENA methodology for the city and proposed numbers. And it's going to be finalized October of next year. But this is what those numbers look like. Right now, it's proposed at 1,731 units. And I'll just give you a side-by-side comparison of what that looks like. So in our current RENA cycle, 683, our proposed RENA cycle, you're looking at 1,731. Now, that's a big number, but I want you to pay attention to the above moderate number. The above moderate is 828 units. Those are typically, basically, market rate units. So you can kind of eliminate that out of your mind and not kind of feel pressure or anxiety like, oh my God, 1,731 affordable units. It's really 1,731 minus 828.
Still a lot.
It's still a lot. But we're pretty good with how we achieved our last RENA allocation. And so I just don't want you to be too scared. It's less than 1,000 units of affordability.
They should be concerned.
And so RENA in the future. So what do we do now? So a plan is worth 1,000 units. So we have to consider where we are, how to accommodate the new units, and the tools that we'll utilize to incentivize those hard-to-come-by affordable units. And so some of the keys to the future. So the current zoning, we have residential and mixed-use zones that can accommodate up to 30 units per acre. And I kind of want to direct your attention at the map that's on your desk or the dice in front of you. And just for those online watching, the map that they have is just a general plan map, and that's available on our website, cityofhawthorne.org. Click on the link for planning. And when that comes up onto the left, you can have access to the link. Give me a call at my office. I'll tell you how to get it, 310-349-2973. And so if you take a look at that zoning map, the general plan map, that's how we're building today. And so if you take a look at the back of that map, it has tables, and that table tells you exactly how many acres we have of land dedicated to residential units. Let me just grab that map. So for residentially designated property, we have 1,236 acres of land, which equate to 38.5% of the city's entire
Land area.
land designations. Thank you. And so just kind of give you a breakdown, commercial, we have 13 acres of commercially designated land. Industrial, we have 10 acres. I'm sorry, that's the percentage. We have 426 acres of commercially designated land, and we have 330 acres of industrially designated land. So for the future, we will have to be innovative and inclusive in our planning and consider all options. And so what are those issues going to be in order to do that? Can we do it? How, when, where, and what tools are these? Okay, so
Yeah, so let's expand upon this discussion a little bit. So when we did our last workshop with the Planning Commission and the City Council, we talked about how the Southern California Association of Governments was developing the RENA. And so they were responding to numbers that were coming from the state, so it's kind of a trickle-down theory. The state started out with this huge number, over 1.3 million, excuse me, and SCAG then distributed it between all the different cities. SCAG ultimately asked for a determination, basically a challenge to the state to see if they could redo the number, maybe lessen a little bit, because it was all based on population projections, housing, jobs, all these different things. The state only reduced it by a very small amount. But SCAG then took that number and they reevaluated the options that they were considering. And you may remember, and you'll see it in the memo that I had provided, that there were 3 options, options 1, 2, and 3. At the time we did the last workshop, we expected anywhere from about 1,400 units up to almost 7,300 units being required within the next housing element cycle. The concern just another month or two ago was that the state may be leaning more towards option 1 or 2, which could have required us to have 4,000 or 5,000 units within this next housing element cycle. What SCAG has done is that they've taken all the public input, all of the letters and the kind of the cries coming from the various cities, and recognized that if it's too many units, it's just not achievable. So at this point, they've come up with the number that Chris has just indicated, which is the 1,731. It's still a big number. So if you compare what you've had to provide in your last housing element cycles, the last one being the 628, this is almost triple what you had to provide for before. And Chris, based on the current land use plan, did you provide land use designations that were basically targeting that 628? Or do you have land use for residential that greatly exceeds that 628?
we were able to exceed it. We were going to exceed.
Right. But some of the properties that you've designated probably are not well suited for housing?
Right. One of the properties that were designated for housing was the federal building. We recently changed the zone, so housing isn't allowed there. And that was 11 acres.
It was quite a few acres. I think you also have an Edison location
Plant,
that's
correct.
also,
Mhm.
so you have an Edison plant, which is not likely to go away. So what will happen as we come up through our next RENA cycle and ultimately to the housing element is that the state is going to be a little bit more focused to make sure that you're doing what you're supposed to be doing. So I believe they will have staff actually looking at your land use plan and field auditing to say, does that property actually have the capability of providing those many units? There'll be more truthfulness in the way that we have to provide for our land use plans and our housing elements. And the reason I say that that's important is that while you may currently have some capacity that's above your current RENA numbers, which is over the 600, to get close to that 1,800 means that you're going to have to relook at where you put residential within your community. There have been several things that have happened over the last couple of years. One, the FAA building no longer has residential. You've also had some changes in your zoning ordinance where densities have been lowered. So in reality, you don't have the same densities that were within your housing element at the time it was adopted. So when you start in 2020 to look at your housing element that's required in October 2021, be mindful of properties that may be better suited for housing and maybe are better locations to have higher density, because you will need to be able to demonstrate that you can meet that, that number. If you're not able to provide for that, you will not have a certified housing element. And you may remember when we talked about this last time, the states now put consequences in for not having an approved housing element. They can actually fine you, and in the worst case, they can actually take over your land use authority and do your housing element for you and tell you where you're going to put your housing. I don't know if the state will ever get to that, but that is the threat. That's the consequence. So I think cities are going to have to be much more kind of thoughtful in how they provide for future land use planning. Hawthorne's had a tendency over the years to be a little conservative with housing, not wanting to necessarily see the larger developments that you're seeing in kind of West LA, Santa Monica. And I get that. That can be very appropriate. But if you now have requirements that you have to have the density, you need to think about where in your community can that be accommodated. You do have some larger developments that are currently under construction. You have the transit-oriented development that's over on Crenshaw.
Green line,
And that's about 200 and how many units?
234.
234. What density per acre did that come in at? A lot.
Mhm.
So initially, the state had said quite a few years ago that if you're around 30 units per acre, that should be good. You should be able to meet your obligations. Based on these new numbers that are coming from RENA, I have a belief that you're going to have higher density in certain locations, otherwise you just won't meet the number. What you're typically seeing when you have 5-story and higher residential structures is that you're at 65 units per acre and or greater. That density is not something you want to see in all of your community. So you have to be kind of strategic. You have to be a little bit surgical in terms of where you find kind of those nodes of activity where it's appropriate to kind of centralize that residential. So we're not here to provide you any real answers, but we want to make sure that your eyes are open and that you're listening, because within the next 2 years, you're going to be asked as a planning commission to start doing the heavy lifting in terms of evaluating how to provide for this land use planning. So, and we're here to answer any questions that we can tonight.
If I go ahead, please.
Will we have workshops? Once the city is looking at rezoning areas to accommodate the new RENA numbers, can you provide a workshop for the Planning Commission that identifies potential areas that you're thinking of rezoning to accommodate a higher density, to maybe give us some input on where those specific areas can be?
Absolutely. Maybe
Yes.
Chris, you can explain the public hearing process.
Yes, I mean, and beyond the public hearing process, when we did this in 2014, I mean, we went out, 6 months in advance, and we noticed multiple times the entire community. We did have workshops. We did have multiple meetings with the Planning Commission. So to answer your question, yes.
Okay.
Yeah, and I think just to further that, this is going to be a very important topic for every community. So I think you're going to have probably neighborhood meetings, you're going to have community workshops, you'll have workshops before the Planning Commission, and then ultimately you'll have public hearings where you will be looking at your housing element and your land use element to specifically identify how you provide for the various housing objectives. That will ultimately go to the city council, and they may agree with you or they may change things, right? So it's important to create more of a community consensus. You will never have everybody agreeing on this. You'll probably have some people who will be very entrenched saying, we don't want Hawthorne to change. So education and communication are going to be key. My guess is that ultimately the city is going to want to be compliant, because there are a lot of benefits that you get from being compliant with your housing element. There will be more and more grants that are available, more and more tools that will help you provide other amenities, features, and services. So while you have to do things that you may not like, you will ultimately receive some things that may benefit the entire community. But I think the commission, you know, I often say that you're kind of an ombuds person. You know, you're kind of an intermediary between the community and what's happening at the city council. You're helping to identify policies, procedures, goals, and objectives, all those things that help make the community a community. So we will be asking you to be a real active member in terms of being able to communicate this information. You know, I think ultimately where the density will be going is probably along a lot of your commercial corridors. You do have a couple of large properties that may be very well suited for housing. In the past, they've been discussed for various housing projects. Maybe that's an opportunity to revisit if the density should be higher. But I'm also mindful of the timing of when you do this. Because as Chris was just mentioning, this is a housing element that's due in 2021. We don't want to give away all the density up front, you know, and then all of a sudden still have this obligation later. There's also the threat that the state may create kind of this cumulative requirement that if you're not creating the units that are required, you may have to provide further rezonings and land use designations for more and more housing. We mentioned at the last workshop that, you know, if your developers are coming in and just developing market rate housing and you're not developing any of the affordable housing, and all of a sudden you've used up all of the land that's designated for residential, you will most likely now be found to be out of compliance with your housing element, and you'll have to find more properties for housing. Some cities are using different tools in order to address that. Some cities are doing inclusionary housing where they require affordability with each project or each project of a certain size. Other cities are using incentive zoning so that it's more than just like the density bonuses that you've seen in some of the other projects. You're actually creating kind of a lower threshold for what would be by right development, but you're creating much higher density if they include affordable housing. So it's kind of a carrot in order to provide for those who have less means to be able to afford housing. And there's probably other tools that can be considered as well. Some cities are using trust funds where they're having developers pay an impact fee, which then goes to the housing authorities or other agencies to develop housing. You know, the city does have some funds available through its successor agency, which is now its housing authority, to develop affordable housing, but that's a fairly small pot. There's not a lot of money there. It won't go very far. So we'll need to look at other examples, other cities that have kind of forged good paths that are successful, and that may be good for Hawthorne as well. Because right now you have somewhat limited opportunity to be able to provide for the broad range of housing that's currently being required in today's housing element, but certainly in the housing element that's to come.
I just want to add, you know, for the benefit of the commission, this didn't really catch us off guard. We've been planning for this for some time because our 5th cycle is almost over. So we knew that we would be having to update the housing element. We knew that the arena numbers were going to be high. We didn't know they were going to be this high, but we have been thinking about some innovative approaches. And so we've been doing some research in the background already. So we're not going to come to you completely unprepared. We've been doing our due diligence.
If I may, so if we did provide these housing objectives and they remain vacant, what then? Like we provided all the housing that they're requesting, we added all these units, and they weren't occupied. What then?
It will. As long as they're constructed, we're good. So the numbers that I showed you, that what we've accomplished, those are actually units that were constructed up into 2018. And so we still have units that are under construction now. Some of them are still have an affordability component. So our arena numbers are going to get even lower just for the 5th cycle. But the vacancy rate of the unit isn't what is going to...
But I mean, how is that going to impact the city if we were able to provide them and then they remain vacant, which means that, you know, people maybe want to live elsewhere that's less expensive. Even though it's affordable, it's still more expensive than what they hope for. So if we build all of this and remains, I mean...
Well, let's start off with the baseline that the state does not require us to build the housing. The state requires us to provide the land use designation to prove that the housing can be built. It's ultimately up to both the private marketplace as well as those who are working with government to try to actually build the housing. I don't think anybody's going to build a bunch of housing if there's not support for it to be occupied. There has to be a revenue stream to be able to pay for all those loans and all those costs. But given the amount of demand that there is for housing, it's unlikely that you would have unoccupied housing, at least not very much of it.
And my other thing is, I mean, ever since we've started the housing element and a long while back, I always keep hearing that the benefits that we receive if we comply. I would very much like to have another workshop regarding what the benefits are. I mean, what benefits are we really getting from complying?
There are some that are tangible as we speak, but there are others that will be coming. You know, the state recognizes that, you know, cities need resources in order to plan for the type of housing. So a lot of what's been available so far has been small amounts of money that are provided for updates to specific plans and zoning ordinances and all of that. But the bigger monies are coming in the form of transportation, the ability to be able to fix our streets, the ability to be able to provide for parks and recreation services, and other types of services that support communities as a whole. And there are millions of dollars available through that.
Okay. Thank you.
I had a question. Would live work land uses in commercial areas count towards the RENA numbers? And,
Yes.
Okay. And also mixed use development?
Correct.
Okay. And then when can we appeal the number?
So, tomorrow actually they're gonna take these numbers and they're gonna do a review. And October of next year is a brief appeal period, but the appeal process has changed, and so there's not much we can do as far as an appeal because of everything that went through and to get in. I mean, we will if.
Yeah, there still is an appeal process, because right now the appeal process has been between SCAG and the state. That has now been resolved. So there is a meeting tomorrow with SCAG where they're taking it to their board and getting basically a buy-in on this proposed methodology, and that's the one that's come up with the 1,700 and plus units for us. Once SCAG agrees that that's their methodology, they then resubmit it back to the state. The state has an opportunity to appeal and try to get it changed. But if the state agrees to it, then it goes to the process where SCAG presents it back to the cities. Now, technically, we have the ability to appeal. If we think that they've somehow misunderstood the formulas or misapplied the formulas or information, then we may be able to get some change in our numbers. However, the ultimate numbers that have to be provided for within the SCAG region don't change. So if we had, for example, if we just had 100 units that needed to be provided between all of us, and you know, one of us said, well, I can do 5, and another one said we can do 10, but nobody else wants to pick up the others, it's still going to get distributed, right? So if there's an appeal, if one of our neighboring cities appeals and their number gets lower, our number may actually go up, right? So that's why in the presentation that Chris did, he said that these are the proposed numbers, but they won't be final till October of next year. Next summer, we will have the opportunity to formally appeal. Not likely it will change much, but you should be aware that your numbers could go higher if somebody else appeals and they're successful. Yeah, and ultimately it'll be the council's decision whether or not they want to appeal.
Is there any way we could prepare to appeal just in case the council decides to do that? Like prepare for that now?
Well, we still have a number of months before we need to prepare anything, so we need to make sure that we understand what the final methodology is and what the final numbers will be that are presented back to Hawthorne. But yeah, certainly if the city wants to appeal, we can do so.
Okay.
But it's a matter of being able to find something that we think has been incorrectly applied or incorrectly determined. Just to be able to say we don't want to do this is probably not the basis of an appeal. I think some cities, however, will try to use physical constraints as a reason to change their numbers. If they can, really be able to demonstrate that they just don't have the physical capacity to be able to provide that number of units, that might be something that SCAG will be considering. And that's again why I think some of these numbers may change, because some cities have more ability to accommodate growth than other communities do.
Okay. Thank you.
Okay, thank you very much for great workshops. Look forward to more. Okay, commissioners' reports. Any folks have anything?
I just have a quick question. Are we up to date with our ethics training? Has it expired or?
It's every 2 years, and I think the last time we checked,
We did it online, most of us.
if you did it online, I think an assistant from our office, Sam, made sure that everyone had complied. I think you guys are up to date for 2 years.
Okay.
I'm not sure about new commissioners. I believe you did do the training, though. Did you do it online? I think you said that you had.
I had to do the training twice for the other commission.
That's right. Okay, good. So I think guys are up to date. Most of you are, but it's every 2 years. So if you
Yes.
did it this year, whether it's online or otherwise, you're fine for some time.
And how can we check? I mean, I can't really remember.
I can check. I can ask our staff. Our assistant has copies of the certificates, or should have copies. So I'll ask him.
Thank you. That's it. Thank you.
Okay. No other comments? I have a very important notice to pass on to you tonight. So mark your calendar for November the 20th. We will not have a planning commission meeting that night.
We're giving you a night off.
Nice. Okay.
We met today for 3 meetings.
There you go. But you'll have a big meeting in December.
There being nothing else or any other business, it'll be adjourned at 7:55.
Thank you, everyone.